I'm Jennifer Babisak. I am an attorney, so not affiliated with, not working in a school, but I bring my street cred. I homeschooled for 12 years, and now my kids go to Faith Plano. My husband is the athletic director there. Because I'm an attorney and attorneys are annoying, I'm going to start the presentation with some disclaimers. So what I'm presenting on today, which is educational freedom, that is not my practice area. I have practiced, I've worked in education law and policy, currently not doing that. So it's just a personal interest. So I don't have as much on the ground experience. I'm not aware of maybe the legal issues that you're facing in your churches and schools. So feel free to chime in with those if you have some of that on the ground experience. I'm not offering legal advice. I'm offering information. I encourage you to seek legal counsel from someone licensed in your state. I'm licensed in Texas. And finally, I do need to give a shout out to my firm that I recently switched firms very recently, and they were gracious enough to honor this commitment for me to be here this week with my family. So I'd like to give out a shout out to them. It's an investment firm, and we advise people on charitable giving to churches and manage church trusts and endowments. So I have some information there if you're interested in us speaking to your church or school. We go all over the country to do that. So afterwards, if you want that, it's up there. And my business cards too, if you want my contact information. All right, I think those are all the disclaimers, so we can get started. All right. So a little overview. We're talking about educational freedom in general. We're going to start by running through, hopefully, a brief history, some of the major Supreme Court cases that got us to where we are today, and then think about some current concerns and look at a case study, which I got from this book. It's a case study of the yeshivas in New York City, and it's a great book. It presents, like, each chapter is written by a different education policy thinker or attorney, but it's worth it. It's worth the purchase for the footnotes alone. Hundreds of footnotes that delve into all the issues I'm talking about today and more. Okay, so we'll get to that at the end. I'm going to try to, like I said, try to talk fast. Okay, so first of all, where is the right to education in the Constitution? Does anyone know? Okay, trick question. It's not there. There's no fundamental right to education in the Constitution, nor has the Supreme Court ever, said that there's a fundamental right to education. So it's not there. So how did the government get involved in education in the first place? We're going to play a little constitutional amendment trivia. All right. So I don't know if you can read this font. The power is not delegated to the United States by the Constitution, nor prohibited by it to the states or reserved to the states respectively or to the people. What amendment is that? The 10th Amendment, good. So states have this power. The states have the police power to act in the interest of the general welfare. So they would say public schooling and compulsory education is in the general welfare, and they regulate it. And that's why, for the most part, states regulate our education system, right? Okay, I have a few more, and I think they're coming up all at once, but we'll take them one by one. I think there's like a little pointer, huh? Okay, let's do this one first. This one's like a quagmire. Nor shall any state deprive any person of life, liberty, or property without due process of law. What amendment is that? That's the 14th Amendment. We'll see that coming up in some of the cases we'll look at. And then these two go together. They're from the same amendment. You probably know this one. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise of religion. So what amendment is that? Girls? Do you know? It's the first. Yeah. Okay, and we'll see that coming up in some of our later cases. The religion clause of the First Amendment was not applied to the states until the 1940s. So some of these earlier cases, we'll see they couldn't be based on freedom of religion. All right, a couple other considerations for federal interference with education. Well, we have, the Department of Education that has their hands in education, right? I was just looking at the history. I didn't know the history. The Department of Education was established as a cabinet level agency in 1980, so fairly recently. And then when Reagan was running, he promised to abolish it. And obviously that wasn't done. So at first there was conservative opposition to the Department of Education, and then conservatives wholly embraced it to the point that by George W. Bush administration, with No Child Left Behind, they increased the budget to the Department of Education by $14 billion. So both parties are complicit in where we are today with that. And then also we have federal entrance into education and special education, of course. And while I say there's not a general, guarantee to education, special education, children with disabilities are entitled to a free, appropriate public education. You'll hear that acronym. And of course, children in private schools still have some of that guarantee, not at the same level, and we won't get into the details, but happy to answer questions if you're looking to integrate special education services through the public schools into your private schools. All right, so this is not safe necessarily, this level of no federal right to an education, which would bring, of course, consequences. There was a recent case, Gary B. versus Snyder. This was a case brought by Detroit school children and their parents. And it was an awful situation in the Detroit schools. They go to length, describing the situation. They were in schools where they lacked books, they lacked teachers. The schools were infested with rodents. I don't think they had proper heating. It was terrible. And the children said they weren't receiving a basic education. They weren't even receiving an education that provided literacy. They didn't have enough desks. It was just a terrible situation, right? So they say, we're not receiving an education, and this violates our equal protection under the law of the 14th Amendment. They said, I agree with this. I liked this. They say that the schools, they were forced to attend or schools in name only, and so the state cannot justify the restriction on their liberty imposed by compulsory attendance. And I agree that, compulsory attendance was a restriction on their liberty, and they'd probably be better off going to the library, getting a few books, and learning at home. And so all this to say that the children asked the court to recognize a fundamental right to a basic minimum education. I think they defined that as literacy. And it made it to the Sixth Circuit Court of Appeals, and they did recognize it to a panel, and they did recognize that. It went through some various motions, and they asked it to go to the whole Sixth Circuit, and they vacated it. Meanwhile, the kids in the state, it changed to Whitmer, as you know, from Snyder, but then the state settled. So this is not binding. But you see how close it got. The Sixth Circuit recognized their right to a fundamental right to education, which would come with consequences. A while back, there was a case in Texas, 1973, that kind of had the same situation, but made it to the Supreme Court. San Antonio, some parents were arguing that their kids weren't getting a basic education because of school funding issues. They lived in a poor neighborhood. They weren't getting equal funding. And a panel in Texas agreed, and they called education a fundamental right. That went to the Supreme Court, and the Supreme Court overturned it. So that to say, we have to stay on our toes with this federal right to education. All right, so compulsory education, I think perhaps you've gathered my opinion on that. How did we get to where we are with compulsory education? This undergirds the whole need for any litigation, right? If we didn't have compulsory education, kids could go to school, not go to school where they wanted, it wouldn't matter. So first compulsory education law in 1642, that was in Massachusetts. And then, I saw my pointer. Horseman, he was Secretary of Education in Massachusetts, one of the reformers of this period starting around 1837, where they were really pushing the common schools, and it was successful, and pushing compulsory education laws. So, that's starting in 1837. By 1900, 32 states had compulsory education laws. In 1918, Mississippi was the last state to enact a compulsory education law. And we're to the point now, I don't know if any of you are from Illinois. I saw a recent ProPublica report on this extensive system of like quasi courts for truancy, and they're issuing parents tickets, and a lot of these parents, they don't have money to pay bills, and now they have these hundreds of dollars worth of tickets because their kid has been truant, and there's this whole enterprise that this compulsory education has led us down that path. Of course, the other hand of that, it went right along with child labor laws and trying to protect children. So a lot of considerations there. But what has compulsory education done? What has it accomplished? Perhaps it's protected children from workforce injuries. But here's some statistics I found on literacy rates. Like 1790, American male literacy was 90%. By 1840, literacy, and I assume that's males, in the North was 95%. In the South, probably including, the slave population, former slaves, was 81% literacy even in the South. And then by today, roughly 79% as far as functional workable literacy. And that would leave 43 million Americans deficient in working literacy. So compulsory education has not been entirely successful for raising the literacy rate. In Massachusetts specifically, where this all started, the literacy rate was 98% in 1642. Now it's 91%. Okay, so the cases we're going to look at today, they consider these basic key questions. Who is responsible for ensuring children's education, parents or the state? Who should set the minimum standards for education? If there's conflict, who should prevail? And does a parent's religious liberty outweigh the state's interest in an educated society, or is it the reverse? All right, so the first case we're going to look at is Meyer versus Nebraska, and this is a good Lutheran case. It was in 1923, a Lutheran school teacher, he was teaching reading in German, and there was anti-German sentiment at this time surrounding the war. And so Nebraska passed a law that forbade teaching in a foreign language under the 8th grade. I guess they said in high school you could learn a foreign language. And so, this teacher, the school, challenged that. And it went to the Supreme Court, and they said that, as I said, the First Amendment was not applied to the state until the 1940s, so that wasn't available to them. So they based it on a 14th Amendment liberty interest of the parents. And so they said, the fundamental theory of liberty on which all governments in the Union repose excludes any general power of the state to standardize its children by forcing them to accept instruction from public teachers only. So they were saying they couldn't exert that level of control. Unfortunately, this case also affirmed compulsory attendance, was the first case to affirm compulsory attendance at the federal level as valid law. So I have this little quote that you may not be able to read. A lot hinges on this definition of a 14th Amendment liberty interest. And as we'll see, that goes to the present day. So here's a quote from Justice McReynolds defining liberty under the 14th Amendment. He says, liberty denotes not merely freedom from bodily restraint, but the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, establish a home, and bring up children, to worship God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. This is significant, as we'll see in current cases. Privileges long recognized as at common law as essential to the orderly pursuit of happiness by free men. So clearly, abortion doesn't fall into that category, which is the most relevant topic to this discussion of liberty currently. Okay. I also have to, because of this setting, whenever I found a little classical material in the Supreme Court's decision, I had to bring that out. So you'll see that here, he's talking about the state interest does not include standardizing its children. It does not have that authority. And so I thought this was clever. He brought in some Plato. He compared the desire to create a homogeneous American society to some of the ideas that Plato also articulated. So he says, for the welfare of his ideal commonwealth, Plato suggested a law which should provide that the wives of our guardians are to be common, and their children are to be common, and no parent is to know his own child, nor any child his parent. The proper officers will take the offspring of the good parents to the pen or fold, and there they will deposit them with certain nurses who dwell in a separate quarter. But the offspring of the inferior, or of the better, when they chance to be deformed, will be put away in some mysterious unknown place, as they should be. And then he talks about Sparta to submerge the individual and develop ideal citizens, which is what Nebraska's wanting to do here, right? Sparta assembled the males at 7 into barracks and entrusted their subsequent education and training to official guardians. Although such measures have been deliberately approved by men of great genius, their ideas touching the relationship between individual and state were wholly different from those upon which our institutions rest. And it will hardly be affirmed that any legislature could impose such restrictions upon the people of a state without doing violence to both letter and spirit of the Constitution. So he's saying the Constitution does not leave room for the state's interest in creating a homogeneous society or for socialization. All right. Okay, so the next case soon after was Pierce versus Society of Sisters. This was in Oregon. Oregon made a law that basically outlawed private schools. They said children ages 8 to 16 have to attend public school. And so a Catholic school, was upset. Also some secular schools like Hill Military Academy joined the Society of Sisters in this case. The Supreme Court said, you can't do this. That it unreasonably interfered with the liberty of parents. Again, the First Amendment wasn't available. It wasn't applied to the states yet. The First Amendment liberty interest, religious liberty interest. And then also because Hill Military Academy had joined the Catholic school, it wouldn't have been a First Amendment religion. Uh-oh. What did I do? Okay. They come back. All right. There we go. All right. So this was decided on the 14th Amendment liberty interest too. And it said that, parents have the liberty to direct the upbringing and education of their children. So this quote, I love this quote. The lesson I identified from Pierce, we should not leave the education of our children to the state. It's articulated very well here by Justice McReynolds. He says the Child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations. So while I love this quote, I love this sentiment that we have a duty to carefully think about our children's education. Pierce and Meyer led to some really sad outcomes as we see, what the 14th Amendment is used for. So another lesson from both of those is just to think carefully about the legal precedents we're using as we argue for education freedom. I'm not sure what they were supposed to do at that time, but this led directly to Roe and Casey, and it was just addressed in Dobbs as well. So have a quote here. This is from a Roe concurrence, and it's been mentioned several times along the years in this whole string of privacy cases. But here's one quote from a Roe concurrence. Certainly the interest of a woman in giving of her physical and emotional self during pregnancy, and the interest that will be affected throughout her life by the birth and raising of a child, are of a far greater degree of significance and personal intimacy than the right to send a child to a private school, protected in Pierce, or the right to teach a foreign language, protected in Meyer. So we see what happened there. We see where those precedents led. I will read what Justice Alito is saying. I know we're getting sidetracked a little bit. I think this is important because there's been huge discussion of substantive due process. There's been significant criticism of Thomas's concurrence in Dobbs, right? And it's all around this issue of the 14th Amendment liberty interest. So I'm just going to sidestep for a moment, and I'm going to read what Alito said in response to this reasoning. This is from Dobbs. He said, "Nor does the right to obtain an abortion have a sound basis in precedent. Casey relied on cases involving the right to marry a person of a different race, the right to marry in prison, the right to obtain contraceptives, right to reside with relatives, right to make decisions about the education of one's children, and many others in that line. Respondents also rely on post-Casey decisions like Lawrence v. Texas and Obergefell. These attempts to justify abortion through appeals to a broader right to autonomy and to define one's concept of existence prove too much. Those criteria, at a high level of generality, could license fundamental rights to illicit drug use, prostitution, and the like. None of these rights has any claim to being deeply rooted in history. Remember when we saw that? What sharply distinguishes the abortion right from the rights recognized in these cases is something that both those decisions acknowledge. Abortion destroys what those decisions call potential life, and what the law at issue in this case regards as the life of an unborn human being. None of the other decisions, including these, cited by Roe and Casey, involve the critical moral question posed by abortions. They are therefore an opposite. They do not support the right to obtain an abortion. By the same token, our conclusion that the Constitution does not confer such a right does not undermine these cases in any way. Thomas went further, of course, as you've probably heard, but I like this quote. He said, substantive due process, which is this 14th Amendment liberty right, is an oxymoron that lacks any basis in the Constitution. All right, moving on and getting back on track, we're going to skip ahead, 50 years to Wisconsin v. Yoder. And this is an Amish case. In 1972, the Amish parents challenged compulsory high school. They were like, we're fine with education through 8th grade. But they said after 8th grade that education was unnecessary for their way of life and that it endangered their children's salvation. This was interesting. It brought in a Lutheran pastor because the Amish did not believe in going to court to settle disputes, and they believed in turning the other cheek. Well, you're going to get far with this, with that approach. So a Lutheran pastor intervened, and he formed a committee, like an organization, the National Committee for Amish Religious Freedom. And he helped them out, provided them with legal counsel, and they won the case. So that was great. So the Supreme Court found, they were not required to attend school after 8th grade. And they listed a whole host of reasons, which we'll get to later in the case study, because that case is relevant to this. Okay, what did we learn from Wisconsin v. Yoder? Showing sincerely held religious beliefs and basing any of our arguments on that is key. In the opinion, they talked about Thoreau, right? And they were like, yeah, Thoreau's basing his lifestyle choices on secular philosophy, and that wouldn't hold up, but this is a sincerely held religious belief, so it does. And then also, I love that the Supreme Court in 1972 seemed to understand more than 95% of parents do today about the dangerous atmosphere of public high school. So I think I have one quote here. Okay, so this is the majority opinion talking about the Amish view on high school. They view secondary school education as an impermissible exposure of their children to a worldly influence in conflict with their beliefs. It takes them away from their community physically and emotionally during the crucial and formative adolescent period of life. And the court also said, it seems clear that if the state is empowered to save a child from himself or his Amish parents by requiring high school education, the state will in large measure influence, if not determine, the religious future of the child. So we see the current polling statistics reflect this. What public high school, what percentage of them leave Christians, right? And the Supreme Court recognized that basically in 1972. All right. I'm going to skip that for now. Hosanna Tabor is one that I think has implications for what we do in schools today. I'm a transactional attorney, which means I like to prevent problems before they happen, right? Write contracts really well, policy manuals really well. This speaks to all that. So this was an LCMS teacher. This was a called LCMS teacher in Michigan, I think. Anyone familiar with the case? I think it was Michigan. And she developed narcolepsy. And she went on leave, and then she said, 6 months later or so, she said, okay, I can come back. My doctor says I can come back. And I don't know the backstory or the inner workings of all this, but the school said, we're not comfortable with that. We don't think you're ready to come back. And then she came back and she showed up and she was like, okay, I'm here, I'm ready to work. And they said, well, we already have a replacement for you. And she said, well, I'm going to sue. And then the congregation rescinded her call because they said, we don't think that you're able to serve. And also now you've exhibited hostility because you haven't gone through a biblical resolution process with us. And so then she did sue. She filed a complaint under the Americans with Disability Act with the Equal Employment Opportunity Commission. And it went to the Supreme Court, and they held that the church, under what's called the ministerial, this affirmed what lower courts had used, and but the Supreme Court had never affirmed the specifics of the ministerial exception, which gives churches and religious schools great latitude in hiring, firing decisions of teachers. This case makes me sad. I don't like people with disabilities to be fired, right? But it applies to moral considerations of our time in hiring and firing staff. And so that's what I'm more concerned about. So from Hosanna Tabor, the Supreme Court lists some factors to consider, in determining whether someone is a minister of the church. I think for us, I don't even think they need to go through the factors for a called teacher, right? But I think the real concern is for lay teachers and paying careful attention to those contracts. I think I talk about some of that on the next slide. Okay, here are the criteria, the 4 Hosanna Tabor factors. The employee's title, degree of religious training required for the position, how the employees held themselves out to others in their job duties. They said this fourth was the most, this one was the most important. You know, I think about my husband who is in colloquy now, and obviously the people who hired him know him, but what if he had a different agenda? He doesn't teach religion within his PE classes, right? This is shaky ground you're standing on if you have someone with an agenda who somehow is hired in your school. So, I haven't seen his contract. I don't think he has a contract yet. So, so I don't know. Maybe they do address in the contract. I have no idea. Something to consider: carefully evaluate those contracts for lay teachers, and then also consider, are there dispute resolution contract provisions like in the contract? That teacher, she said, "Oh, I didn't know that I wasn't supposed to sue the school. I didn't know I was supposed to try other things first." Maybe make that explicit. All right, I know I'm running out of time here. I'm going to skip. So I have this case, Trinity Lutheran, which is the playground case. The state or the city, I think they were giving like grants for playground resurfacing, and they qualified, but then they said, you can't have it because you're religious. And the court was like, no, this is a neutral benefit. They can have the money for the playground. And that kind of goes along with Montana v. Espinoza, school vouchers. Yes, religious schools can use vouchers. And then Carson v. Macon decided 2 weeks ago. So the Supreme Court kept me on my toes with this presentation. Again, yes, they can use vouchers. I do want to talk about something that I believe is relevant to all our plenaries we've been hearing. The dissent in Carson v. Macon, I think I have it because I can't remember if it was Sotomayor or Breyer, but they said, yes, religious schools can use vouchers, of course. It's just a problem if they teach religion at these schools. Like, if you're a religious school in name only, I mean, we're all for you, right? Which is exactly the type of religious school that we're trying to avoid. I couldn't hear very well this morning. Did Pastor Boyce say you should just close, right? Okay, this is Breyer. He said, Maine chooses not to fund only those schools that promote the faith or belief system which the schools are associated, but those schools present material taught through the lens of faith. I mean, can you believe it, right? So that's the problem. That's the problem they have. And we've seen this, right? We've seen this with, just in general, a legal philosophy. You're not restricted from practicing your religion due to COVID restrictions. You're entitled to think whatever you want and believe whatever you want in your mind, and you're not restricted from religious thought. You're just restricted from going to church. But we're not restricting your religious practice. So it's just a general philosophy that they generally think is legitimate. So that's all I'll say there. Just the lessons I have from those is, yeah, vouchers are constitutional. Proceed with caution if you use them. And we don't really have time to get into all the considerations for using school vouchers, so I won't. Oh, I can't leave out the homeschoolers. So quick history of homeschool law. We talked about compulsory education laws coming into being. Before then, of course, people were going to homeschool. The first homeschool legislation that defined and legalized homeschooling, 1956 in Nevada and then Utah. And then activists began criticizing the public school system. So the homeschool movement began gaining momentum. And by 1993, homeschooling was legal in all states. In Texas, it was pretty close to that later date that a Texas Supreme Court case legalized it, which is just shocking, right? It took that long. But of course, we've experienced a pandemic surge in homeschooling. Homeschooling statistics are hard to collect. One statistic I read said it had surged from, I think, 3% in 2019 to 11% of all American school children at some point in like fall 2020. So who knows where it is now, but the surge in homeschooling is drawing scrutiny, which is likely to push for regulation to both homeschools and private schools. For instance, in Texas, a homeschool is considered a private school. I believe that's the case in Indiana as well. This is just a map of homeschool regulation taken from the Homeschool Legal Defense Association. Obviously, you want to be in a green state, and if you can't, try to be in a light blue state. Okay, so threats to educational choice that we face today. Here are a few that I just mentioned. Increased regulation, right? So following the pandemic surge, or maybe just before, in homeschoolers, there was that Harvard professor. Do you remember that Harvard professor that came out advocating for a presumptive ban of homeschooling and equating it to child abuse? So these people, I mean, popular opinion, right? And that kind of thing is going to come out of the woodwork more and increase calls for regulation as it gains popularity. I spoke about hiring and firing conflicts. I'm sure you're aware of Babisak, which was the Title VII case. Title VII is an Employment Discrimination Act. Babisak read into that case that sex included sexual orientation and gender identity. So now that's included in Title VII, and that creates problems, right? So think carefully about those contracts. International actions, running low on time. This book goes into a lot of what's going on in schools internationally. In Europe, I'm sure you're aware, there's this pushback against the perceived or actual threat of Islamic, extremism, right? And so they want to crack down on Muslim schools. So they're cracking down on all homeschools and private schools. And it details that. Of course, that in this day and age, what's going on in Europe has sway here. So I guess my point there is we have to advocate for educational freedom for all religions. It doesn't work under our Constitution to say, well, Christians, but not Muslims and not Jews. We have to advocate for educational freedom for all religions. There's a chapter in this book that actually goes into statistics on extremism in children who have attended like these certain rigorous Muslim schools, and it says it's actually like less, much less violence and extreme beliefs. So I don't know. All right, I've got like 7 minutes left to cover this case study, so I'm going to leave that there. So the whole controversy, this is good because it's kind of an extreme case to evaluate what do I think? How far should education and freedom go? So these New York yeshivas, they fundamentally teach the children from the Torah and Jewish canonical texts. And I think yesterday, Pastor Petro, you asked about like what's the balance, right, of scripture and these classical texts. So they're taking the balance pretty far, and they are like the pyramid mentioned, it would just be maybe a tiny or non-existent slice of secular text. So people are some children who graduate are complaining. Some parents who leave the faith are complaining that the children aren't prepared to interact with the secular society. And so in response to some of this, New York passed these educational guidelines that required private schools to provide a substantially equivalent education. And it includes some specifics on teaching secular subjects, inspecting the schools. And non-compliant schools can lose access to public aid or have the children who attend deemed truant. So as far as I can tell, it's just such a political thing, right? Because the politicians are afraid to upset the Jewish community too much because they need their votes. But yet, so the last thing I saw was they're still pushing forward with, you have to complete these inspections, but there hasn't been, I don't believe there have been yeshiva closures. So it's still kind of in limbo. But say they get serious about closing them down and enforcing these laws. What defenses do the yeshivas have? Out of the constitutional precedent that we've seen, which case do you think most applies to this controversy? They're saying we're not receiving a basic education. We can't. Some of them, there's debate that I've read over whether they're even fluent in English upon graduation. So what case that we've reviewed do you think would be most applicable? Gary B for the fundamental, but that's not precedent, right? It settled and it was vacated. Okay, so Yoder, right? Yoder. But Yoder has some things going for it that the yeshivas didn't. It was well established, like the Amish style of life, right? It was well established in U.S. history, where people could argue that Orthodox Jews were not as well established in U.S. history. They also brought, I don't know if these were appropriate arguments, but people have mentioned that the Amish will not take welfare, and so the state's concerned about having dependent citizens. Like the Amish were not going to be dependent on the state, whereas the Orthodox Jews do not have that policy. And so there's several ways that the Yoder differs from this, but it's a possibility that they could use that as a constitutional defense. RFRA, the Religious Freedom Restoration Act, it was a federal law passed in 1993 to kind of push back against some restrictions on religious liberty, including an unfortunate case that was authored by Scalia. But so RFRA was a federal, it's applied federally. But then a few years later, they said, oh, but it doesn't apply to the states. And now I think like 21 states have their own RFRA laws. New York doesn't. So that doesn't help them, but you may have a RFRA law in your state that would help you in a similar situation. New York does have some state constitutional protection for religious freedom that the yeshivas could possibly turn to. So this hasn't, this is still in process. These are just some thoughts and a modern day application of what we've gone over today. This book goes into great detail. I recommend it, Religious Liberty and Education. I got it on Amazon. I have like 1 minute for questions. Yes.
Is there any concern about the connection of compulsory education to like child abuse laws and removing children from parents? Like I'm a social worker by trade and also a foster and adoptive parent and a pastor's wife. So, and a homeschooling mom. So trying to figure out if there's potential for legal connections between, like I know when we went through our social work program, there was a connection between truancy and the ability for Child Protective Services to step in and remove a child because their parent was keeping them from education. Is there concern that that might become part of the conversation?
That is part of the conversation. Advocates for a presumptive ban on homeschooling, for instance, would say, we need this because who is going to detect the child abuse if the children aren't in school? Children need to be in school so that we can detect the child abuse. So yeah, that is part of the conversation. And I mean, it's an evil world, right? There's going to be child abuse, but it's just determining whether you feel that the parent should be the one to make the educational decisions, or whether the state's interest in protecting children from child abuse outweighs the parent's interest in making educational decisions for their children. But yes, very big part of the conversation.
Yes. To what extent do we have to be worried about sort of growing expanded use of the interstate commerce clause to try to define everything, and including the education of children and their eventual welfare? And what sort of defenses would we have for blocking that sort of expansion?
I think that's probably too much for us to get into. Yes, the Commerce Clause is the way it's been used as a problem, and yes, I could definitely see it continuing to be a problem, and it could be used for almost anything under the sun, right? So, yep, that's another problem. By the way, I talked a lot about 14th Amendment issues. Justice Thomas thinks that many of these substantive due process cases should have been decided on privileges and immunities from the 14th Amendment. And I think Justice Kennedy suggested he would have gone with freedom of speech or, of course, religious liberty if that was available. Any other questions? Again, I have material up here. I have cards. Feel free to, I'm can't give legal advice, but happy to serve as a sounding board for anyone. Thank you.